Hi, Alecia Daniel Hall, Florida estate planning, probate attorney, and realtor. If this is your first time visiting my channel, please don't forget to like and subscribe so that you will be notified as soon as I upload new videos. In this video, I will be going over the key documents of estate planning. There are four key estate planning documents that you need to be aware of. The first and most commonly known document is a will. There are a lot of misunderstandings and misconceptions about what a will is and how they work. First of all, a will is a legal document where an individual is going to determine how they want their assets to be distributed when they pass away. They are going to name the beneficiaries, who are the people that are going to receive the benefits of those assets. They're going to name a personal representative, and that is the person who is going to be responsible for administering the terms of that estate. In a will, an individual is able to identify how they want their assets to be distributed when they pass away. They can name individual assets that are going to be passed to specific people. They can name beneficiaries. Those are the people that are going to be receiving those assets. You can name guardians of your minor or incapacitated children. And you also will name the person who is in charge of administering the estate. In other words, the person who's going to be responsible for carrying out your final wishes. This person is a personal representative here in the state of Florida. One of the most common misunderstandings about a will that I deal with regularly is people are unaware of the fact that a will has to go through probate. I get it all the time since I'm also a realtor. People will call me, they want to list mom's house, and the first question I ask is, okay, is there a will? And when they say yes, I say, great. Was the will probated? No, mom left the house to me in the will. That's not how this works. The will only serves as the instructions for how things are going to be distributed after you pass away. A will without probate is literally just a piece of paper. It must be probated by a court in order for the probate process to get started. A will must be admitted to probate by a probate judge. And the probate process is required in order for those assets to be transferred. The next key estate planning document is a durable power of attorney. In a durable power of attorney, you are naming an individual known as an attorney in fact, who is going to have the ability to handle and manage your financial affairs if you become incapacitated and are unable to do so on your own. One of the important benefits of having a power of attorney in place is it is automatic. A durable power of attorney goes into effect as soon as you sign it. So once you become incapacitated, your loved ones will not have to go through a court guardianship process in order to have the right to actually stand in and access your bank accounts and handle your finances. If you do not have a power of attorney, your loved ones will have to petition the court, and as a result, there's going to be time and an expense involved with getting the right authority to handle your finances. The third key estate planning document is a living will. A living will lets everyone know how you feel about having your life prolonged by artificial means. With your living will, you are letting everyone know how you feel about having your life prolonged by artificial means. If you have a serious illness and you are left in a persistent vegetative state, but you have a living will, no one would be required to guess at what your wishes would have been. The fourth key estate planning document is a living trust. Now, a living trust is not something that's needed by every person. It really depends on your circumstances as well as your goals. A living trust is a legal instrument that provides for the management of your assets. Living trust, you're going to identify the assets that you want to be owned by the trust, and you're going to name a person who is in charge of taking care of. Basically, they are the manager of those assets. That person is known as the trustee, and you can be the trustee of your living trust. The assets in your living trust will pass outside of probate court when you pass away. And one of the great things about a living trust is you can incorporate control mechanisms. Living trusts are not necessarily going to be in everyone's estate plan. It really depends on your circumstances and your goals. But it is very important that you discuss trusts with your estate planning professional to determine whether a trust might be beneficial to you and your needs. Ready to get started with your estate planning? Click on the link below to schedule your free estate planning consultation.